I wish to acknowledge the traditional custodians of all the diverse lands we are meeting on today. I recognise the deep history and ongoing connection that traditional custodians have with land, waters and community. I extend my respect to them. I extend my respect to their cultures, and I extend my respect to elders past, present and emerging. Today I am in Brisbane, or Meanjin, so I would particularly like to acknowledge the traditional custodians of the land that I am on, the Turrbal and Yagara peoples. I recognise their culture and the rich contribution that both the Turrbal and Yagara people have made and continue to make to the region in and around Meanjin. Finally, I wish to conclude by extending my respect to any First Nations people who are present at this event today. Thank you.
Thank you very much, Melinda. For those who don't know, Melinda's actually head of the ACCC's Enforcement Division, so that just shows what a versatile lady she is. I'd like to certainly acknowledge the VIPs in the audience. We're currently up to almost 400 people, and the count is going up quicker than I can watch it. We've of course got members of the Business Law Section Executive of the Law Council of Australia. We've got Rod Sims, who's the chairman, and commissioners and senior executives of the Australian Competition and Consumer Commission. And most importantly, we've got representatives of the Bannerman family. I believe we have Marilyn and Bruce and Sally Dell as well, and others who I haven't managed to spot in the massive lineup there. My name is Philip Argy. I'm the chairman of the Business Law Section of the Law Council of Australia, of which the Competition and Consumer Committee is one of our many specialist business law committees. I'm going to start off the proceedings today by announcing our 2021 prize winners. We offer a number of prizes for scholarship in competition law. The first one is the 2021 Baxt Prize. That's of course named after one of the Law Council's most esteemed alumni, the late Professor Bob Baxt. The 2021 prize has been awarded to Nick Angelakis for his paper titled Unfair Preferences as an Instrument of Restoration. In his paper, Nick examines preferential payments made by a related entity to an insolvent corporate debtor and the rationale for and relief that flows from a preferential payment under Part 5.7b of the Corporations Act. In doing that, Nick also considers competing decisions of intermediate appellate courts which promote conflicting rationales for the avoidance of unfair preferences. Nick is an associate in the Commercial Disputes and Insolvency team at Mills Oakley, a law firm in Sydney and Melbourne. He graduated from the University of Adelaide with honours in 2018 and is presently undertaking a Master of Laws at the University of Melbourne, where he's completing a minor thesis on the adjudication of proofs of debt in corporate insolvency. From 2018 to 2019, he was the associate to the Honourable Justice Sifris of the Supreme Court of Victoria, and Nick practices in corporate insolvency, commercial litigation and secured debt recovery. So congratulations to Nick. The 2021 Gare Blunt Scholarship, named after another very illustrious alumni, was awarded to Michael Vozdenovic for his paper Nascent Digital Acquisitions, Anti-Competitive Mergers or Misuses of Market Power. That paper examines the effectiveness of Australia's merger control prohibition in respect of potentially problematic digital acquisitions and possible alternative solutions under the statute. Michael concludes that Australia's misuse of market power provision can be deployed and may provide the regulator with greater success in enjoining digital mergers. Michael is a solicitor at Clifford Chance in Sydney, working on competition and consumer law matters and commercial law disputes. He's also a Fulbright scholar, presently undertaking a Master of Laws at Columbia Law School, just down the street from where Lina is, having graduated with a Bachelor of Laws and a Bachelor of Economics from the University of Sydney. And Michael was previously also an associate, this time to Justice Michael Wigney of the Federal Court of Australia, and he's also been a researcher for the Competition and Consumer Law Reporter. So congratulations to Michael and Nick, and Jessica will be in touch with arrangements on getting your money to you, which are handsome sums, I must say. We do have a third prize, but it hasn't been awarded this year, to be blunt, for want of quality of submissions. So that's just encouragement for people to do better for the 2022 prizes. Now, I absolutely want to acknowledge what might be Rod's last official outing by paying tribute to his very distinguished career. I'm going to have a bit more to say in about 5 weeks' time when Rod's term officially ends. I think he's waiting till after St. Patrick's Day. And obviously, I'm also going to say some words of welcome for Gina and Liza to the Commission. But in brief, and putting to one side that special hairstyle Rod's had during COVID, his term as chair of the ACCC has been marked by his firm but fair style. Rod's tenure has brought with it definitely increased clarity on the ACCC's purpose, objectives, and priorities. He's elevated its status from that of a pure regulator to one of regulator, educator, advocate, policymaker, and enforcer. We might not always have agreed with Rod's views, but you always knew where you stood with Rod, and that's pretty important when you're advising clients, and certainly critical to the ability to engage in robust debate. There's no doubt that under Rod, Rod has made a material and lasting difference to Australian consumers in particular. He's championed product recalls, product safety issues. He's run some carefully targeted litigation against some scoundrels. He's seen increased Australian consumer law penalties and law reforms, but certainly he's had a key role in putting Australian consumer law at the forefront of consumer protection policy internationally, and he certainly made Australian businesses sit up and take notice. So if you were wondering about that second C in ACCC, Rod's really made that count for something. Just a couple of highlights, I guess, that spring to mind, as if his commitment to take on losing cases on day one wasn't sufficient. They certainly included global leadership. Rod's been really very active, I think, in the global competition regulation space, and is well regarded just about everywhere, or in fact everywhere. And certainly he's led on digital issues, even in the early days, and Australia is at the forefront there. Rod's taken on the first criminal cartel cases in Australia. He's been involved in changing the misuse of market power provisions. I think he's the only ACCC chair with an opera, but we'll put that to one side. And of course, Rod's love of AFL, and that scarf has been backdrop in almost every Zoom and Teams meeting. We're not seeing it today. I'm not sure why, Rod, but I think it's one of the few meetings we haven't seen that scarf. But look, I now want to call on Rod, not for a right of reply, but to say something about the genesis of the Bannerman Lecture, and of course to introduce our guest speaker for today. So over to you, Rod.
Thanks very much, Philip. Those are very kind words, and I wasn't expecting that today, so I'll try and recover my equilibrium. I was about to try and take the ACCC background effect off, because as soon as I do, the scarf plus the footballs that represent the 2013, 14 and 15 premierships will be on display, so I might do that fairly soon. But thank you very much for those kind words, Philip. Really appreciate that. Look, it's my pleasure to also welcome everybody to this wonderful event. And I'd also like to welcome and acknowledge the members of Ron's family who are with us today. We're really always delighted that you can attend this event, and I know you'll keep attending this event well into the future. I'd also like to thank the Law Council for co-hosting this event for the 8th time, and for the many more times to come in future. It's really a testament to the strong continuing relationship between the ACCC and the Law Council. Now, of course, this lecture is a tribute to Ron Bannerman. It is the most important competition talk in in the Australian competition calendar. Ron, of course, was an amazing individual, which all those who remember him will quickly attest. He focused on the possibilities rather than the many drawbacks of the 1965 Act, and he brought it to life. In fact, his work made possible, I think, the far-reaching TPA, Trade Practices Act of 1974. Ron brought resilience, humanity, and constant courtesy to the role. These qualities, plus his hard work, laid the foundation for what we have today: the ACCC, the CCA, and a vibrant competition community, most of whom are with us today. Now, of course, the pandemic has brought enormous negatives, which we're all aware of. But the one positive is, of course, virtual meetings. This allows us the privilege of having Lina Khan deliver the 8th Bannerman Lecture. With her current responsibilities, of course, she would not have been able to take the many days out of her schedule that are required to make the journey to Australia, particularly at this time in her tenure. Lina was sworn in as FTC chair in July last year. She is, of course, extremely well qualified for the role, given her sheer intelligence, her presence, her strength of purpose, and her clarity of vision. I've had a number of chats with Lina and have always come away deeply impressed at all levels and struck by her warmth as a person. Lina is, of course, very widely known for her writing on the impact of monopolies and concentrated markets, not only on our economies, but also on our societies and communities, and the role that antitrust can and should play in addressing this. Right around the world, Lina has helped reframe discussion of the purpose and rightful scope of competition law, arguing that the use and interpretation of the consumer welfare standard, particularly in the USA, might blind us to practices that may be genuinely harmful in ways not captured by this framework. Lina has had an immediate impact in her job. For example, she's refiled a huge antitrust case against Facebook. With the DOJ, she has launched an inquiry to examine the US merger guidelines, and she has signalled that she won't back down against the forces already gathering to resist her changes. Now, I want to emphasise that we do need to question antitrust. In my view, it is not delivering sufficient competition so that our market economies can work as expected. Indeed, sometimes antitrust can be seen more to protect than challenge those with substantial market power. I'm honoured and delighted to introduce Lina and to thank her for making time in her absurdly busy schedule to address us today, or in her case, Wednesday evening. Over to you, Lina. Thanks very much.
Thank you so much, Rod, for that extremely generous introduction. And good evening, everybody from the United States. I'm so pleased to participate in this year's Bannerman Lecture. Ron Bannerman had a remarkably prescient commitment to developing competition law in Australia, and it's been thrilling to watch Chair Rod Sims and the ACCC build on this critical work and help shape contemporary discussions about the future direction of competition law and policy. From the ACCC's sophisticated work on digital markets to Chair Sims' specific proposals on merger reform, the activities here are influencing the work of many agencies, including my own. The ACCC's experience is informing two of my priorities in particular. First, approaching competition and consumer protection in an integrated fashion, which I know that Rod has been a deep champion of. And second, integrating technologists in the agency's investigative and policy work. I'm also very grateful for the ACCC's international engagement, including its leadership of the International Competition Network's project on the intersection of competition, consumer protection, and privacy. This work has critically surfaced key interconnections, including the ways in which concentrated control over data can enable dominant firms to capture markets and raise entry barriers, the ways that commercial surveillance practices can equip dominant firms to closely monitor and thwart emerging competitive threats, and the ways that market power can enable firms to degrade privacy without facing market ramifications. Given that the competitive significance of data has been underappreciated by enforcers across the board, breaking down these silos to better grasp the interconnections is key to ensuring rigorous analysis and effective enforcement. The ACCC's commitment to international cooperation has been of particular importance with respect to digital markets, given the global scope and operation of many of the companies involved. The ACCC has undertaken sophisticated research into various aspects of digital markets, contributing significantly to international understanding. This work, along with the work of other agencies around the world, has already advanced our shared efforts to promote fair competition in these markets. As additional segments of the economy continue to digitize, investing in and acting on this shared learning is critical. While digital markets have been a key area of the ACCC's pioneering work, the focus of my remarks today will be merger enforcement, another area where Rod has advanced the discussion. Since joining the FTC last June, a significant portion of my efforts and energy have been devoted to examining how we can better harness our tools to check unlawful mergers. Rod has similarly reflected on the Australian experience with merger control, and last year proposed that the government pursue a number of reforms to enhance the agency's ability to review and intervene in potentially problematic transactions. For competition agencies, halting mergers that may substantially lessen competition or tend to create a monopoly is one of our most critical tasks. Last year saw an astounding merger wave. Global deal-making in 2021 soared to $5.8 trillion, the highest level ever recorded, with the US antitrust agencies receiving more than double the number of merger filings received on average in any of the past 5 years. This significant increase in deal volume has threatened further concentration in our economy, further entrenching incumbents and undermining open markets. While merger enforcement in antitrust circles is often discussed as a matter of technical expertise, it's critical to keep in mind the material, real-world stakes of under-enforcement. Unchecked mergers can mean that patients in rural communities are having to drive hours to access critical medical care, or workers are seeing their pay stagnate or even decline, or life-saving technology might never be developed. The supply disruptions spurred by the COVID-19 pandemic have underscored how consolidating supply and prioritizing efficiency over resiliency can render our markets more brittle and much more vulnerable to shocks, where a single disruption can have cascading effects. Recalling these material stakes and the very real costs of under-enforcement is paramount. Recognizing these costs of undue consolidation, President Biden in July issued an executive order on promoting competition in the American economy. The order notes that corporate consolidation across markets has accelerated in recent decades, weakening competition in sectors as varied as agriculture, technology, healthcare, and telecommunications. The president's call to action envisions a whole of government approach where the competition agencies and sector regulators alike are tasked with using their policy tools to combat excessive concentration. In particular, the president called on the FTC and DOJ to reinvigorate merger enforcement work that can halt monopolization on the front end. We know that we have a lot of work to do and that the success of the US approach rests on our adapting and evolving with the facts and the evidence. While we face serious constraints that we do not control, most notably our limited resources, we are focused on identifying how we can update the tools and processes that do fall within our control. The recent wave of mergers has increased the urgency with which we are pursuing this exercise as we consider changes on a range of fronts. A critical component of effective merger enforcement is an appropriate merger notification and review regime. Last year, Rod proposed reforms to Australia's merger control system to correct what he and others see as weaknesses in the Australian system: voluntary notification with a non-suspensive regime and a substantive test that is biased towards clearance. He provided a roadmap for reform. including the adoption of mandatory notification with suspensive effect, the ability to review transactions that fall below merger thresholds, a less demanding substantive standard of review, and consideration of special standards for the largest digital platforms. In light of this discussion in Australia, I thought I would share a few reflections on the US experience. No doubt, mandatory pre-notification of mergers that are above a certain size has become a foundational component of our modern antitrust regime. It is also now widely accepted as such. Of the nearly 100 jurisdictions with merger control, only a handful have a voluntary notification system. And the vast majority of the regimes are suspensive. That is, the parties are not allowed to close until the statutory deadlines have run. Notably, the US merger review regime also allows our antitrust enforcers the ability to review and, if necessary, challenge non-notifiable transactions. The notification thresholds do not establish nor limit jurisdiction. They determine only which transactions the parties must notify prior to consummation. Decoupling thresholds from jurisdiction has allowed the agencies to focus their review on the deals that are most likely to raise competitive concerns while retaining the ability to review problematic below-threshold transactions. Determining how to set appropriate thresholds and what metrics beyond the size of the transaction and the relevant parties might be key proxies for competitive concerns is a critical question. Authority to review transactions regardless of notification is particularly important in order to address growing concerns about concentration creep and roll-up strategies that can involve relatively smaller acquisitions that fly below the radar. In addition to retaining jurisdiction over non-notifiable transactions, the US agencies can also review and subsequently challenge consummated transactions, even if they were previously notified. Importantly, a pre-notification regime must give enforcers sufficient time to review proposed transactions. In the United States, the competition agencies have 30 days for an initial review, and before that time expires, we must decide whether to conduct a more thorough investigation. The length of the second review period is determined by the merging parties within 30 days after the companies have provided substantially all of the information requested. The FTC must decide whether to take enforcement action. In practice, these time periods too often are insufficient. 30 days has not been enough time for us to conduct a comprehensive and rigorous analysis of most of today's deals. Legislative history shows that the lawmakers who conceived of the US pre-notification regime envisioned that the antitrust agencies would review around 150 mergers annually. Today, the US agencies routinely receive 150 filings every 2 weeks. Coupled with the increased volume and complexity of transactions and their related data and documents, the 30-day timelines have proven inadequate. Surges in merger filings, like the one we experienced this past year, have only underscored the acute strain that these timelines create, sometimes compromising our ability to conduct rigorous and thorough investigations. We are reflecting internally on the best way to address this challenge. For instance, soon after I joined the FTC, the Bureau of Competition adjusted an aspect of its process to make the best use of our limited resources. For deals that staff cannot fully investigate within the short statutory timelines, the Bureau of Competition sends a letter to the parties, placing them on notice that the FTC's investigation remains open and that the agency may later determine that the deal was unlawful. Additionally, the FTC and DOJ are considering changes to our merger notification form to potentially require the provision of additional information that will allow us to conduct more informed reviews within the statutory deadline. Beyond getting the procedural aspects of pre-merger notification regimes right, it's also important to have a clear understanding of its purpose. Pre-merger review should not be treated as a merger application process, where firms view the job of the antitrust agencies to provide customer service to merging parties to help them close their transaction according to their deal timeline. Merging parties and their counsel must recognize that the merger review process marks the beginning of a potential law enforcement inquiry. When proposing deals, especially those that require pre-merger notification, firms must recognize that they are electing to subject their companies to a potential legal inquiry. Another important shift is ensuring that a broad range of stakeholders are contacted and consulted about potential effects of a merger. One priority for me has been ensuring that we are accessible to and hearing from the broader public, including consumers, workers, smaller market participants, and others that might be affected by potentially unlawful transactions. Finally, as enforcers, we ought to think about how best to deter illegal deals in the first place. As part of our efforts to increase deterrence, the Commission recently voted to revive a policy that generally requires companies that are pursuing an unlawful merger to obtain prior approval by the FTC for any future transaction in at least the same product and geographic market for which a violation was alleged. Absent this policy, the agency can find itself reinvestigating similar transactions at the cost of considerable staff time, whereas including prior approval provisions can dissuade firms from proposing anti-competitive transactions in the first place. Lastly, there is growing recognition that competition in the United States has suffered in part because our merger enforcement over the past 4 decades has been insufficient. As we consider how to reinvigorate enforcement, we must ensure that the substantive standards and the analytical tools that courts and agencies are applying match modern economic realities. For over a century, the US Congress has codified a policy in favor of competition over consolidation. In 1890, as trusts captured the sugar, steel, oil, and railroad industries, lawmakers passed the Sherman Act, prohibiting, among other practices, monopolization, attempted monopolization, and conspiracies to monopolize. Once it became clear that this statute was failing to prevent monopolization through acquisition, Congress in 1914 passed the Clayton Act, prohibiting mergers whose effect may be substantially to lessen competition or to tend to create a monopoly. When businesses began exploiting loopholes in the Clayton Act, Congress once again stepped in, passing the 1950 Seller-Kefauver Anti-Merger Act to ensure that the law captured vertical and conglomerate deals as well as acquisitions of assets. With each of these efforts, Congress redoubled its commitment to open markets and free and fair competition. As enforcers, we need to remain faithful to these legislative mandates, while at the same time ensuring that our tools are accurately reflecting the realities of the current economy. With this in mind, last month, Assistant Attorney General Jonathan Cantor and I announced that the US antitrust agencies have launched a joint review of the US merger guidelines. While periodic reviews of existing guidance is good practice generally, the time has been especially ripe to update the US merger guidelines, both horizontal and non-horizontal. In particular, major technological and economic changes have led to shifts in how businesses compete and grow, creating new interconnections and dynamics across multiple dimensions. For us to be accurately detecting, analyzing, and deterring potentially illegal transactions in the modern economy, ensuring that our merger guidelines are reflecting these new realities is critical. We are hoping that a wide range of stakeholders, including those who are most affected by mergers, such as consumers, workers, small businesses, and entrepreneurs, will share their views during our public comment period, which is open until March 21st. While our request for public comment identifies a broad set of topics, there are 3 areas of particular interest that I'm going to highlight. First, are the guidelines adequately attentive to the range of strategies and incentives that motivate acquisitions? Specifically, we hope to learn how the guidelines should address the risk that a merger may create a monopoly in its incipiency, such as through moat building, data aggregation, or roll-up acquisitions of smaller firms. Second, how should the antitrust agencies assess whether a merger may lessen competition in labor markets, perhaps by looking beyond wages, salaries, and other financial compensation as potential harms to workers? And third, have we been unduly focused on particular types of evidence to the exclusion of other important sources of evidence of harm? There has been a wealth of scholarship and research over the last decade on the sources of harm from mergers, and we want to ensure that we are capturing and reflecting that new learning. We also need to be clear-eyed about the administrability of merger standards, which requires asking whether certain approaches have properly served the larger goal of identifying mergers that are likely to cause harm in the long run. Agencies in the past have spent enormous resources towards market definition, including by employing the hypothetical monopolist test and relying on top-notch experts to present highly detailed economic testimony, only to have the judge observe that the dueling experts effectively canceled each other out, equating the task of determining liability with looking into a crystal ball. I think it's fair to ask, who has all of this effort served? Does it result in clarification of merger standards over time? And if not, what can the agencies do to help ensure that courts are understanding the goals of merger enforcement as Congress intended, and thereby use case selection and aggressive enforcement to move the law in that direction? I'd like to conclude with recognition of Rod's service to the ACCC, which I understand he will conclude in the coming weeks. Rod's enthusiasm and passion are contagious, and his efforts have been closely followed and emulated by agency leaders around the globe. His efforts have elevated the ACCC's prominence among competition and consumer protection enforcement agencies around the world in ways that have benefited the ACCC's counterpart agencies internationally. Admirably, Rod's focus has not only been domestic. His efforts to build and strengthen international partnerships has helped increase the efficacy of our common efforts to protect competition and sets the stage for even stronger, more intensive cooperation in the future. Indeed, I was so impressed that Rod even took efforts to testify before the US House of Representatives to share the Australian experience with lawmakers in the United States, though unfortunately at that time, the committee schedule changed abruptly and he was not ultimately able to appear in person as planned. Rod, you have left a lasting mark on competition enforcement in Australia and beyond. You've set a remarkably high standard, and I'm so looking forward to working with your successor, Gina Cass-Gottlieb. Thank you again, Rod, for advancing our collective learning and for your deep commitment to rigorous enforcement, especially during this moment of realignment of competition law and policy. And on a personal note, I've also just been so grateful to you for your warm welcome and advice with which you've been so generous as I've stepped into this role. So thank you again for the invitation, and I look forward to the discussion.
Thank you so much, Lina. That's much appreciated, and I love the way so much of what you had to say resonates with us, I'm sure, both on the regulatory side and on the legal fraternity side. So I'm now going to call on Jacqueline Downs, who's the chair of our Competition and Consumer Committee of the Business Law section of the Law Council of Australia. Jackie's going to moderate the questions, so I invite people to use the chat box and send their questions to Jackie. We don't guarantee that every question will actually be asked, and I'm told that Rod will also be willing to answer questions that might give Lina a chance to grab a glass of water or something in between. So over to you, Jackie, to maybe reflect on some of Lina's comments and to ask some of the questions that will start coming in now. Thanks, Jackie.
Thanks very much, Philip. And again, thank you so much, Lina, for a great thought-provoking speech and for giving us an insight into the FTC's agenda at the moment. Needless to say, you've been a highly anticipated speaker today, and we're privileged that you've been able to speak with us. It is certainly a really interesting time for competition law and competition lawyers. We're seeing competition authorities all over the world, not least, of course, the FTC and the ACCC, re-examining the toolkits they've used for many years and ask, as you have today, is this enough? What else do we need to do? And should we apply new rules in different areas to keep up with the new and emerging issues that we're seeing? And there are no clear answers, no easy answers, especially as technology can be a bit of a moving target. And it's fair to say competition law has always influenced economic outcomes for market participants and consumers, and also, as you've alluded to, Lina, can have a big impact on social issues in labour markets and other related markets. And again, I think spearheaded by you, as outlined in your speech today, we're increasingly seeing antitrust raised in the context of discussions of some of these other social issues. And this has been amplified, as you indicated, by COVID. So a really interesting time in terms of the intersection of antitrust law with those other issues as well. So I will moderate the discussion today. I've got a couple of questions to kick off, although I think I can see quite a few coming through already, which is great. You might have to bear with me while I read some of them. They're a bit lengthy. Can I ask, I think if you post them to hosts, they will just come through to me privately, and I will be indicating who has asked the question. I think that's fair to Lina. So we do have some journalists on board and obviously a cross-section of the antitrust community here in Australia. So if you could let me know who you are, and I will indicate who is asking the question. But Lina, can I just kick off with one of my own? I'm really interested about, you mentioned in your speech issues about concentration creep and roll-up strategies, and you've talked about, you know, the importance in the merger guidelines of taking into account and considering new business models. I just wonder if you can expand on what you mean by that, and whether you have any idea at the moment how that might be reflected in revised merger guidelines.
Thanks for the question. So at this stage, you know, the RFI, the request for information that we've put out, is very earnest in seeking input and guidance, and we're not looking to prejudge any of these issues. But I think, you know, there have been a couple of instances, even within our own enforcement actions and investigations, where we've seen the ways in which it can be important to understand the underlying business model, so that can give us insight into what the underlying deal rationale might be, which can let us further understand what some of the competitive implications of transactions might be. So one instance is, you know, private equity acquisitions. Private equity firms have a particular business model. Oftentimes, you know, they end up flipping the assets, and so that requires us to ask certain questions around what the long-term horizon might look like for these acquisitions. Similarly, firms that have behavioral ad-based business models that incentivize data collection, those types of firms may be, you know, making certain acquisitions with an eye to acquiring new sources of data. And so those are really the types of questions that we are seeking to understand in more depth, making sure that, you know, I think sometimes you can see instances in which there can be a bit of a gap, right? When a deal is announced, Wall Street analysts, financial analysts are analyzing the deal with a particular vantage point and identifying the various ways in which the acquisition might create pricing power, might lead to market power. In some instances, more traditional antitrust analysis, or, you know, an industrial organization approach to viewing the same deal is not going to get us that same type of analysis. And so wanting to make sure that the theory that we're using, the framework that we're using, is more closely mapping onto how actual deal makers and business folks and investors are viewing these transactions, I think is important for us to make sure that, you know, our tools are corresponding to the actual business realities.
Great, thank you so much. Rod, do you have anything to add from an Australian perspective in terms of your proposal for reviewing merger guidelines?
Whoops, yes, I'm unmuted. Look, I suppose, Jackie, I think we're trying to put a bit of focus on the fact that market concentration does matter. I think there's just so much literature on why in certain circumstances it doesn't matter, that the scope of discussion almost gets to the point where concentration doesn't matter, and it's all about a whole range of other things, which of course are stunningly fact intensive and become a source of debate and make cases extremely complex. But I think we do need to start from the fact that structure does matter, and have that as a base. And that's why I think the proposals we're putting that focus on whether a firm has substantial market power in the first place, and whether the acquisition can substantially increase, entrench or enhance that market power, is such an important arm of what we're proposing. Perhaps the biggest criticism I've had is that people say, well, if that were the case, it's already covered under the existing law. Well, my answer to that is it would be good if it was, but we haven't seen that in a number of cases. So I think just getting a bit of a focus on concentration, 90 times, you know, most of the times concentration does matter. Obviously concentration of a certain type, if you're going from 10 companies to 9 companies, that's not going to worry you. but going to a smaller number of companies can, and we need that focus in our law. So I guess if we're trying to, I mean, there's a range of process changes, but trying to get some focus back onto what is the most basic of economic principles, and certainly the most basic business strategy principle. If you speak to any business person, they'd much rather work in a market with 2 or 3 competitors than more. And there's a reason for that. And I think merger analysis in Australia and debate and logic has lost sight of a bit of that. That's a very long answer, Jackie, longer than I intended, but that's what you get when you throw me a merger question, Jackie.
Thanks,
Jackie,
Rod.
can I just abuse my privilege as a co-host to add an observation, and that is
Philip.
the way that concentration can really be increased and leveraged in the online digital world. And I think that's a factor that really could do with some research and study. I believe that those with market power have the ability to leverage that much more effectively in the digital and online world than they've been able to do in the bricks and mortar world. So I'll just throw that into the mix in case that's relevant for later comments. Thanks.
All helpful comments are appreciated, Philip. Thank you.
Thanks, Philip. Just one more from me, Lina, on the mergers aspects before we go to some of the questions from the floor, which are varied. You've also spoken about the non-price effects, the diminishing competition potentially in labour markets, lower wages, lagging innovation. Again, can you perhaps expand on this a little and give us your perspective on the role that antitrust law has to play in relation to those types of issues?
Sure. So in the United States, the text of our statutes prohibit mergers that may substantially lessen competition or tend to create a monopoly. The text doesn't say anything about price, not price. It's really with an eye to competition. And then it's up to the agencies to come up with the tools and frameworks that give us the ability to determine what actually constitutes lessening of competition or the creation of tending to create a monopoly. There are a variety of factors that can be considered, and one part of our current inquiry into the potential revision of the merger guidelines is trying to understand whether there might be an opportunity for greater reliance on direct evidence of market power. Our current approach and the way that cases tend to be litigated in the US courts frequently start with this question of market definition, and you end up engaging in a very technical inquiry. And we're trying to understand whether there might be other types of metrics that would give us insight into direct evidence. And so, traditional types of metrics might include super competitive pricing over a certain period of time where you're not seeing entry that would, in theory, discipline away the super competitive profits. But you can also imagine certain types of quality degradations that could also potentially signal that type of market power or monopoly power. There are traditional metrics of quality. In digital markets, we might also think of privacy degradation as part of that, or instances in which firms are able to renege on certain types of commitments relating to how they might be collecting or using data. And so those are some of the types of factors that are already on our radar, and we're very much hoping that as we do this inquiry, we'll get more insight into other types of factors that we should be considering.
Great, very interesting. Thanks, Lina. Well, look, I will go to the floor now. First question is from David Swan of the Australian newspaper. Lina, what's your view on Australia's news media bargaining code, and do you expect other jurisdictions to follow suit with similar legislation? And do you agree with ACCC Rod Sims that more regulation is the best way to grapple with market power of the tech giants rather than breaking them up? Pretty loaded questions there. If you're happy to answer, Lina.
Look, I'm not able to comment on any, specific efforts underway in Australia, but I think there is a broader conversation in the US as well around, instances where we may be seeing deep asymmetries of market power in certain instances, sometimes between, firms that are dependent on a gatekeeper, and a conversation around what are the various tools that we might have to be able to address that. In some instances, antitrust enforcement and ensuring competition on the merits may be adequate. In other instances, jurisdictions, including the US, have considered other tools, including regulatory tools. And so I think, especially as we confront some questions of first impression in digital markets, is always good to go into those conversations with our full set of tools on hand.
Great. A couple of questions from Laurel Henning of MLEX. So almost all US-based digital platforms have recently rewritten their terms of service so that disputes should be resolved in Bay Area courts. However, you might have read that Australia's courts have recently rejected these provisions, ruling that on public policy grounds, the matters should be heard in Australia if they involved Australian antitrust issues. Do you have any concerns with the platforms setting out these jurisdictional requirements? And is it good for the FTC that competition enforcers around the world are able to pursue platforms locally rather than leaving it to the FTC in the US to lead the charge?
So it's difficult to comment on that issue because it's not squarely before us, but I would say, overall, I think, it's important for enforcers around the world to be able to assert, their law enforcement over their jurisdictions. And in as much as some of these companies really do have a global presence, enhancing international coordination and cooperation and working together very closely is paramount. I know Rod has really been a leader in ensuring and improving that type of international collaboration, especially in instances where different jurisdictions may be looking at the same merger, but might be on, say, slightly different timelines. And so ensuring, close coordination in those types of instances can be really important.
Thanks, Lina. And a second question from Laurel that might be a bit easier for you. How can regulators balance the need for merger reform to deal with the perceived weaknesses compared to the potential economic chilling? Is there a risk that investors will be more risk averse in investing in capital in small business, particularly innovative startups, if there's a risk those startups won't be able to sell themselves?
It's an interesting point of discussion and debate in the US as well. And of course, we always want to be thinking through carefully, before we take any steps. I think, one more recent bias that has been evidenced in both the law and enforcement is a bias towards under-enforcement, right? There has been, in particular in US law, a view that erroneous over-enforcement will be more difficult to correct for than erroneous under-enforcement. The idea being that, market dynamics will correct for any exercises of monopoly power or market power. I think in practice, we've seen that theory has really failed to materialize in a whole set of instances, right? We see that market power, monopoly power can be persistent, the existence of entry barriers or even a history of predatory tactics, that those can actually have a chilling effect on entry. And so I think we also need to be thinking about the ways in which unchecked market power and unchecked monopoly power can also be chilling investment and new business formation and the creation of startups and expansion of entrepreneurs. And so I think thinking about the costs on all sides can be important. And I think if anything, at least the discussion and the enforcement in the US has been biased towards one set of costs. I think what we're trying to do is make sure we're understanding costs on all sides.
I might just jump in.
I was going to ask you, Rod. I knew you would want to say something on that one.
Oh, damn. I should have waited to be invited then, Jackie.
Go ahead.
Often this debate is run by under the heading of enforcers will block all small companies trying to sell out and therefore damage all exit strategies. We just need to be careful. It's always a very effective argument to argue via exaggeration, but really what we're talking about is how do we capture those acquisitions which are likely to substantially lessen competition. Now, obviously, when you've got very small competitors being taken out by dominant firms, that's extremely tricky to do. But if the test is, why shouldn't you block mergers? The question should be, why shouldn't you block mergers that can damage competition? That is the right question. Nothing that I am certain Lina is proposing, or the FTC or Jonathan Cantor at the DOJ are proposing, or that we're opposing, is going to stop most smaller firms exiting. What we are going to do is be keener to see when you've got damaging effects on competition. And I could just add, I completely agree with Lina on these so-called type 1, type 2 errors. I mean, the idea that businesses will be easily chilled is against my 20 years of corporate strategy background. They're not easily chilled, extremely hard to chill business, but the costs of under-enforcement are very large for our society. So we do need to rethink that balance. I suspect it's the most important question facing antitrust right around the world. Thanks,
Rod. The next couple of questions are a bit more at the personal level, Lina. Firstly, from Kate Mahon of the ACCC, what has surprised you most about your term so far as chair of the FTC? And could you tell us about how you've dealt with the expectation placed on you to deliver reform?
So in terms of what's been most surprising, I mean, I think a couple of things. I mean, one is just the sheer number of issues and authorities that Congress has assigned to the FTC. We have, broad authorities that cover the entire expanse of the U.S. economy. So we have our competition work, which is what I've been discussing, but we also have a consumer protection portfolio that, includes sub jurisdictions on issues like, funeral caskets and funeral pricing to, children's pricing, children's privacy. And so I think it's just the sheer breadth of the issues is really quite remarkable. The other issue, frankly, is just how under-resourced the agency is, given the sheer breadth of its mandate and the enormous job that Congress has tasked it with. The size of the agency has really not grown substantially in decades, even as the size of the economy has dramatically expanded. And so those resource constraints prompt very difficult questions around prioritization, and where, constantly the demand for our work is constantly much greater than our ability to supply it.
Thank you. Another question from Marcus Betsy of the ACCC around the news bargaining code and the dairy code, a couple of particular codes in certain industries we have here in Australia, each of which seeks to improve the function of those markets by addressing market power imbalance. What role do you see the FTC taking in relation to the use of its rulemaking power?
So this is a great question. So there's a big debate right now around, whether case-by-case enforcement, which is what the antitrust agencies have done in order to enforce the antitrust laws, is adequate. I think we've seen in a whole set of instances in which case-by-case enforcement has, slowed the development of the law in some cases and can make it more difficult for us to have a market-wide impact. The FTC does have rulemaking authority, which means that it has the ability to promulgate rules defining what constitute unfair methods of competition in terms of specific types of business practices, specific types of conduct. And so, this is not an authority that has been used in recent decades. And so we are thinking through carefully what it might look like to exercise it. The executive order that I mentioned President Biden issued last summer included in it several recommendations for the FTC to use its rulemaking authority to address a whole range of issues, including the use of non-compete clauses in contracts with workers, issues relating to data security and privacy, which we could also potentially address through our competition protection rules. And so, we are in a posture of looking closely at this authority and trying to understand how we might use it.
Thank you very much. A slightly different question from Gerard Brody of the Consumer Action Law Centre. Obviously, we've talked a bit this morning about the new role of consumer law, perhaps the intersection that you're looking at, Lina, and the role that Rod has played with that here in the ACCC over the past decade. So I'd love to hear Lina's comments Sorry about that. I'd love to hear Lina's comments about developments with the FTC's Section 5 Unfairness Authority, given the debate about a similar reform on unfair trade practices in Australia.
Yes, it's a great question. So, so we on the consumer protection side have, unfairness and deception. The Unfairness Authority has been, through statute, there is a kind of a three-pronged test that lays out, what type of analysis we have to do to determine whether certain practices might be unfair. Scholars and experts have suggested that even though this standard is kind of codified in the law, there may be areas where we should be expanding how we're thinking about certain concepts. So one example is, in order to prove unfairness, we need to be able to show substantial injury. There's a conversation around what it would take to think about substantial injury outside of the monetary context. So certain types of privacy harms or dignitary harms. The statutory framework also lays out certain type of balancing of harms and benefits, and so there are discussions around what that actually looks like in practice and whether those harms and benefits should be conferred on the same type of market participants or whether there should be some type of balancing. So those are the types of conversations that are happening around what types of plays in the joints there might be even within the existing unfairness standard. And then on the unfair methods of competition side, this has been a long-ranging debate at the FTC. The Federal Trade Commission was created in part as a complement to the Justice Department, and Congress expressly gave it this unfair methods of competition authority with a recognition that you would sometimes need an authority that was slightly broader than the four corners of the Sherman Act in order for us to be able to, keep pace with business developments and new types of business practices. And so, almost since the inception, there's been a big discussion around what it actually, what is that part of the authority that goes beyond the four corners of the Sherman Act. And there are, various case decisions over the last century that lay out particular types of factors that the agency might want to consider, including around oppressiveness and coercion. So there is a history there that we're also looking at to try to understand if we are to move forward here, what that would look like. One of the actions that the Commission took last year was to repeal a policy statement that the Commission had previously adopted that effectively pegged our unfair methods of competition authority to the existing antitrust laws. And, we thought it was important to kind of reclaim the broader authority that Congress has given us. And so we're now taking steps to think through what it would look like to give clearer definition to that.
Great.
And Jackie, if I can jump in and just supplement that with an observation again in the technology and online space about whether things like, major search organizations changing their algorithm can completely change the competitive dynamic for a whole lot of businesses that are dependent on the way they've done it previously, or other big platforms just changing small things or almost seemingly on a whim can significantly affect people. And there's some really interesting arguments about whether that's unfair, because of course they do have a commercial relationship with those who use the platform. So yeah, that's an area which I would like to see a little bit of focus on as well, both here and offshore.
Next question, again, slightly different direction from Damiano Fritz of Clayton Utes. Lina is referring to your article, your well-known article, of course, Amazon's antitrust paradox, where you explored the possibility of the essential facilities doctrine being applied to digital platforms. Has your experience as FTC chair affected your thinking on this?
So of course, arguments and work that I pursued as an academic were as part of a different line of work. But I think, on this particular question, I think the one appropriate avenue for discussion is in Congress, where there, over the last year or so, have been a whole set of legislative proposals introduced, thinking about, how we should address the market power of firms in the digital sector. And there we have seen, reliance on and focus on a whole set of concepts that we previously applied to, natural monopolies and dominant intermediaries in other contexts. So essential facilities is one of those concepts, but we also have seen legislation considering non-discrimination principles as they might apply in this sector. We've also seen legislative proposals that envision potential types of line of business restrictions or structural separations, which was another policy tool that was applied in the context of other types of dominant intermediaries, be it in the railroad context or in banking. And so I think overall there is a discussion around whether the types of tools that we use to govern dominant intermediaries in other contexts, we should also now be extending to digital markets. And so I think that discussion and conversation in Congress will continue.
And Rod, what's your perspective on that? Do you think there is a role, a similar role in Australia?
I think that the way Lina finished up there is exactly right. We do have a range of what I prefer to use in the economic jargon, ex-ante rules that apply in banking, telecommunications, energy. So it's not unheard of to use those tools. Also, of course, you've got the Hilmer Part 3A reforms, which very much followed a debate about whether we use unilateral conduct to deal with issues where competitors to Telstra wanted access to the copper wire so they could compete in telecommunications. Hilmer decided that Section 46, unilateral conduct, wasn't going to be sufficient. So we have that access regime. So that's a classic ex-ante rule. So I think certainly the knee-jerk reaction that says, no, you shouldn't go to ex-ante rules, you should rely on ex-post enforcement is, I mean, that's just not an answer at all, because we've already crossed that road. The question is, what's the right framework to regulate these industries? And I think the point I think really matters is that when you're taking court cases, I mean, I've looked very closely at many issues in relation to the digital platforms, and when you look at the court cases, you just have to narrow down so much about a particular bit of conduct being against the law, that if you win on that, you've got a declaration from a court about a bit of conduct, but the platforms are so, that their presence is so broad, they can achieve that in other ways. So after the 5 years of work, you actually haven't had the impact on the market that our normal enforcement work is supposed to have. I mean, normally, if you look back at many cases, they have changed many markets in Australia, but it's just not clear that ex-post enforcement is going to change the markets in the way they need to change here. So having some upfront rules, they'll mainly be standard competition rules about what can and can't happen, making them in a sense more per se than SLC. But there also might be consumer rules, going a bit back to Jared Brody's question. I mean, there's no reason why you wouldn't use those ex-ante powers to come up with consumer changes, laws that protect consumers as well as protect competition. I mean, I'm again going on too long, but I think the pervasive impact of these companies and the way they affect what we do, the small number of companies that affect so much part of our lives, it's just so fundamentally important to the future of our economies and communities that we get this right. So I'm really not, I mean, I'm just focused on making sure we have the debate, we get it right, we keep talking about it, we keep moving forward, and laws progressively get passed to deal with these issues. And I do think the News Media Bargaining Code was one such step, a step in a particular sector, but I think there'll be many more of that to come, Jackie, because I think there has to be. It's just too important to our whole society for there not to be.
And maybe just expanding on that, Rod, a question from Mark Nottingham, and I might ask you to comment on this first before perhaps if Lina has any additional thoughts about the intersection, now with technology and in particular internet governance and the role of coordination between different authorities, privacy regulators and so forth. How do you see the different regulators coordinating with each other on these issues?
I'll look exceptionally closely, Jackie. Obviously Lina's got one advantage over everyone else in the world, in that she's competition, consumer and privacy, so she can coordinate amongst herself. But we've set up, I think we can call it the Quad. I think there's 4 agencies. One is ourselves, ACMA, e-safety, privacy. I may have missed one, so it may not be a Quad. And we meet regularly to go over all the issues, because the overlap is just enormous. I have a very strong view that we should not set up a digital regulator that only focuses on digital. I think that will run off in the wrong directions. I think you want decisions about how antitrust affects digital to be taken by the antitrust regulator. You want how digital affects privacy to be done by the privacy regulator, so that you integrate privacy and antitrust. And you can't do that if you set up a digital regulator and take all those out. But you do need the coordination, and we are meeting very regularly. It's a very conducive environment where everybody comes to the meeting with a similar idea of trying to get it right. So that's a regular discussion that's being more and more formalized. It's getting itself I can't remember what the latest title is, but it was quite a catchy one, but not catchy enough for me to remember it. And we're getting clear terms of reference established as well. So it's definitely going to be formalized and be more public than it has been up till now. So I think it's crucial that there's coordination both within countries, between the agencies affected, and of course between countries, as is obvious as we all deal with these problems. Yeah,
I'll get to between countries in a moment, but just Lina, is there anything you'd like to add on how the sort of inter-agency coordination is being dealt with in the US?
I'll just echo what Rod said in terms of that type of coordination and collaboration being essential. I think especially as we see more and more parts of the economy digitize, these issues affect regulators and enforcers across the board, right? So one example is as AI technologies and algorithms are being more and more incorporated in all sorts of different types of functions, questions around potential bias are now coming up in all sorts of contexts, including in how certain types of government benefits are being distributed, in terms of how employers what type of hiring practices they're implementing. And so the set of laws that govern all sorts of practices are now having to adapt and adjust based on new technologies, based on more digitization, and based on the adoption of AI. And so we are working very closely with government partners across the board on these issues. I think just to go back to what I was mentioning earlier around consumer protection, competition, and privacy in particular being a really critical nexus. I think the conversations that are happening internationally around this are critical. And the United Kingdom has had a really interesting example of coordination among their 3 enforcers and regulatory bodies. So that's something that we've been looking at closely as well.
Great. And then talking about the interagency in terms of different jurisdictions, Australia and the US obviously having a particularly close relationship, and even talking about stronger, more intense cooperation in the future. Rod, I might start by asking you to expand a bit on your new role at the ICN and how you see that influencing this relationship, and then perhaps ask Lina's perspectives on the Australia-US agency relationship.
Yeah, thanks, Jackie. It's just a step along the road, I think. Obviously when I joined the ACCC and went to the ICN 10.5 years ago, cooperation was a big issue, but it had a lot to do with information sharing on cartels, competition cases, merger enforcement, talking about theories of harm. But the conversation has definitely moved on to talking about coordination of how particular cases are handled, potentially even making decisions at around about the same time. I mean, obviously each country's got to go through its own procedures, so that's not always possible. And also talking about how to enhance the tools that are available so that there's some joint approach on that. And obviously, when you've got the Germans having already put in place various ex-ante rules, Europe, to some extent, Korea and Japan have done that as well. Europe, UK actively thinking about it. There's just an awful lot of discussion going on around how all that looks now. Sometimes that's discussion amongst competition agencies, sometimes that discussion around policy agencies, but the collaboration, I think, has broadened in the time I've been there, and I think that's only going to increase. Jackie?
Thanks, Rod. And I think this might be our last question for you, Lina, if you've got any reflections on the closeness of those ties between the agencies.
So, I think especially under Rod's leadership, the relationship between our agencies has been really fantastic. Rod in particular has really taken the initiative to be regularly engaging on digital matters with enforcers across jurisdictions. And then under Rod's leadership, the FTC was also able to join the multilateral mutual assistance and cooperation framework for competition authorities, what basically gives us a basis for even closer cooperation and collaboration, allowing, sharing of certain types of information and that sort of thing. So I think that's, only given us even a stronger foundation to continue close work together.
Great. Well, look, that wraps it up. Thank you very much, Lina, for answering those questions. I apologise. There were many, many more questions. We really couldn't impose on Lina any more. She's already given up so much of her time to ask those questions, but clearly a lot of interest here, Lina, in the FTC agenda and in the relationship between your agency and the ACCC. So thanks everyone who asked questions, and thank you so much for responding to those questions. And to you, Rod, as well, of course. And I'll now hand over to Stephen Ridgway, who will give a vote of thanks. Thank you, everybody.
Thanks very much, Jackie. I think the Bannerman Lecture is always a special event. It's one of the peak events in the Australian competition law and economics calendar. But I think this tonight, I mean, we could have kept you going till midnight your time, I think, Lina, but that would have been extremely unfair. It's fascinating. But I think this particular event is quite special for three reasons. One, I think we'd all agree that this is a critical juncture in competition law, and whichever decisions need to be made as to how we address market power, whether we address market power, how we deal with mergers, how we deal with the digital giants. And this global debate is clearly accretion of market and exercise of market power is global, and we need the competition regulators need to cooperate. It's also special because we can do it. We've just got the pleasure and absolute privilege of having you speak to us because we can do it virtually. I know in your first year as chair, it would be too much to ask you to travel around the world and distract you from your duties. So we've been in the last couple of lectures before this one, we've been lucky to have the heads of the CMA and the French Competition Authority present, and particularly Andrea Caselli from the CMA last year virtually, and to have you present virtually. And this is, I think, the record for registrations for the Bannerman Lecture, which is a real indication of the interest and excitement at hearing from you. And lastly, this is a point of changeover in both our organisations. I've seen, although I was an adversary of the Commission for many years, I've been a commissioner for the last bit over 2.5 years, and seeing the responsibility and pressure that's placed on the chair of the ACCC, and I'm sure the FTC. Now, this is Rod's last weeks as chair, and I've seen the great things that he's achieved over the decade, and how much responsibility it has to take across the very broad remit. The ACCC has a very broad remit. We don't have privacy, as Rod pointed out, but very broad remit like the FTC. And in your first year as chair, we can see the challenges and responsibilities that have fallen on you, but it's very reassuring to see your grasp, to be able to see in person your grasp and passion of all of the issues, and seeing the issues that are coming up, and for us to work together and see how the birthplace of antitrust law is dealing with these issues and how we can assist. And I'd like to offer that assistance from the Commission as to whatever we can do from our agency to assist. But I think everyone here would just like to extend their great gratitude for you spending this time in your evening out of a very busy schedule. So thank you very much.
Thank you, and thank you so much again for the invitation. It was a real honor, and as I said, I've just been so impressed by the ACCC's work, and I'm sad to see Rod depart, but really looking forward to continued collaboration with the successor and making sure our agencies continue to have such a great relationship. So thank you so much.
Thanks, Lina, and thank you very much again, Stephen. Stephen, of course, has not only been on both sides of the equation, he's also sat in my chair previously, so he has phenomenal experience of almost what all of us have been through at some stage or another. Can I first of all note in closing that the proceedings have been recorded, so they'll soon be available on both I believe the ACCC as well as the Law Council website, so people will be able to watch that again or watch it if they haven't seen it. Can I pay particular thanks in closing to Jessica Morrow from the Law Council and Lisa Ann Ayres from the ACCC for their assiduous logistics planning for this event. I have to say, as Stephen adverted to, we've had a registration of over 720 for this lecture, which is an all-time record. In fact, we had to increase the cap on our Zoom license. We reached a peak, I think I noticed, of about 558 at one point, so that's fabulous. So it's a good thing we lifted it above 500, and I'm sure a vast number of people will look forward to watching the recording. So look, in closing, everybody, I look forward to welcoming you to the 9th Bannerman Lecture in February 2023, and I wish everybody a good afternoon, or in Lina's case, good night.